I got a D in algebra, so maybe I didn't add that up all right.
I have an answer to that. It must have been a clerical error.
Wish I brought my history guy with me. I want to make a couple of little comments and then I'll go ahead and start. My name is Paul Paradis. I own Paradise Sales gun store down here in the Springs. I've been involved in firearms my entire life from probably 5 years old onward. I used to take my gun to school because we had a shooting team at school. So back in the good old days when we didn't have any evil in society, those things were proper and normal. And it's changed over the years. The first thing that kind of struck me, and I've got to tell you, I wasn't really sure what we were talking or debating about tonight. And I didn't want to be argumentative, but I did want to be a little bit enlightening. And the first thought that came to me when we talked about the Second Amendment at all, I got an email about 2 months ago, long before I knew about this. And it really struck me because I looked at the Supreme Court decision in Heller and I'm like, I'm not an English major. You know, they're picking this apart word by word, syllable by syllable, comma by period. It drove me nuts. The bottom line is everybody said we, the pro-gun people, won. And I'm kind of like, well, 5-4 decision doesn't really mean we won because that's too close for me. It means it can be changed very easily. And we've seen laws change over the years from prohibition onwards. It just depends on what people are in power at that particular time. The first thing that I'd like to answer is why do I think the Second Amendment is an individual right? And this email came, and I'd like to read it to you because it really struck me well. If we change just a couple of words in the Second Amendment and read it into a different context, we would all have a different opinion as to all those syllables, commas, periods, and so forth. A well-regulated library system being necessary for the literacy of a free state, the right of the people to keep and read books should not be infringed. Now, how would you read that? As a right only to read books on federal property? I don't think so. I'm in the legal field, and I am probably one of a handful of right-wing redneck conservatives in the public defender's office. I'm very proud to be there. We all come together for the same reason. We want justice, and I don't think that's an issue of the right or the left. And I get debated on a lot of these things often. And the first thing I learned in the debate is there's always two sides. And I don't mean to take offense to some terms, but when we talk about constitutional scholars say, well, there's a number of constitutional scholars that have taken a different mindset, that have a different opinion. Obviously, there wouldn't be any case with two sides arguing it in front of the Supreme Court. We can look at phrases and words, and you can pick the ones that back your side, or I could sit here and read through a number of different ones that would back my side of being an individual right. I love Thomas Jefferson, for one. And if I can give just a couple of quick quotes. I'm sorry, I'm not as well prepared as he is. But again, they struck me as important to think about what our founding fathers thought. First one, Thomas Jefferson quoting Caesar Beccaria. Am I saying that correctly?
It's good enough for me.
Okay, you're the history professor.
He's a judge.
I'm a philosophy, but he's
Oh, I'm sorry.
basically.
Laws that forbid the carrying of arms disarm only those who are neither inclined nor determined to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than to prevent homicides, for an unarmed man may be attacked with greater confidence than an armed man. I don't think Thomas Jefferson was referring to a federal right on federal property. Now, recently an article came out from Mr. Cox of the National Rifle Association that takes a slightly different view. Although I would agree, there is no constitutional right that is an absolute right. We're not allowed, for example, to go into a movie theater and start yelling fire. We don't have the right to do that. The question, and something that we're all looking for, especially those that are strongly for the right to keep and bear arms, is what limitations are going to be put on those rights. And that's going to be a decision probably decided next year. And if I can read from Mr. Cox's article. And I think it will be a little bit of enlightening as to the reason for incorporation and so forth. You bounced around on me a lot, and I kind of got myself out of order. Oh, here we go. Okay. A year after the historic Heller decision, the nation's highest court considers its impact on the states. On September 30th, the U.S. Supreme Court opened a new chapter in its Second Amendment legal history by announcing it would decide whether the Second Amendment applies to the states. The case, McDonald versus the City of Chicago, is one of several that were filed immediately after last year's decision in District of Columbia versus Heller, in which the court struck down Washington, D.C.'s ban on handgun possession, as well as the capital city's ban on keeping loaded, operable firearms for self-defense in the home. The follow-up cases were filed by the NRA and others against Chicago and several of its suburbs, as well as against the San Francisco Housing Authority. They were all aimed at the same goal: establishing that the Second Amendment forbids state and local governments, not just federal authorities, from banning handguns. It's a surprise to many gun owners that the Supreme Court has not yet applied the Second Amendment to the states. To understand why, we have to step back almost 200 years in the 1833 case of Barron versus Baltimore. The Supreme Court ruled that the Bill of Rights only applies directly to the federal government, and that ruling has stood ever since. After the Civil War, Congress was concerned about how to address oppression of the newly freed slaves. Congress passed a series of civil rights laws to deal with this problem, and eventually also passed the 14th Amendment, which says states may not abridge the privileges or immunities of the citizens of the United States, or deprive any person of life, liberty, or property without due process of law. It's clear that the framers of the 14th Amendment meant to protect the freedmen's right to keep and bear arms from those who wanted to destroy their freedom. As attorney and a historian, Stephen P. Fallbrook has extensively documented both supporters and opponents agreed the amendment would do as intended. Just a few years later, the U.S. Supreme Court ruled that the Privileges or Immunities Clause only protected the kind of privileges and immunities that owe their existence to the Constitution or to the nature of the federal government. By that reason, the clause couldn't apply the Bill of Rights to the states because the Bill of Rights protected basic human rights that existed before the Constitution was ratified. This decision in the Slaughterhouse case, 1873, has been criticized by scholars ever since, and U.S. Supreme Court Justice Clarence Thomas has suggested it should be revisited. The decision made the Privileges or Immunities Clause meaningless, contrary to its drafters' clear desire to protect citizens' rights.